joining us for our program today entitled The Top 10 Federal Grant and Contract Pitfalls for Nonprofits. My name is Jeff Tenenbaum. I'm the chair of the Nonprofit Organizations Practice here at the Venable Law Firm, and we're glad you are able to join us for our monthly program, seminar, webinar on nonprofit legal issues. This program is being recorded, as you heard earlier. As many of you know, because many of you are repeat attendees, this is part of a monthly series of seminars and webinars that we do on nonprofit legal issues that we've been doing for the last couple of years now. If you're here in the D.C. area, you're always welcome to join us for a complimentary lunch, which many of you here in the room, about 70 of you here, are enjoying, and we have about 175 on the telephone across the country joining us for our program today. This is the first time we've tackled this topic as part of our monthly series. As you know, we really try to mix it up and cover a wide array of diverse legal issues that are front and center and challenging for nonprofit organizations. This is the first time we've tackled federal grant and contract issues, but it's certainly not the first time that we've dealt with these issues. This is an area that's been an ever-growing part of our nonprofit practice for a number of years now and seems to have really exploded in the last couple of years. One of our speakers is a key member of our team who works with our nonprofit clients in this area, and it seems like not a day goes by where we're not counseling some nonprofits, sometimes dozens or hundreds of nonprofits, on federal grant and contract issues, and hopefully you're going to get the benefit of a lot of that here today. We're very fortunate to have two really talented speakers with us. First, I'll introduce our guest speaker. As you know, for these monthly programs, they generally consist of Venable lawyers, but you can't always just hear from lawyers. We have to keep it interesting, and we're very pleased to have Stephen Steigletter. Stephen is the Deputy Vice President of Grants and Contracts at our client, the Institute of International Education. IIE, Institute of International Education, is a large global nonprofit that works in international student and scholar exchange programs, probably most notable for the fact that they administer the Fulbright student and scholar programs on behalf of the U.S. State Department. Stephen has over 25 years' experience working in grant and contracts administration. He's been at IIE since 2000 and was promoted to his current position in 2010. Prior to joining the Institute, Stephen had 14 years' experience serving in both financial management and grant management positions, ensuring compliance with federal regulations on a variety of large projects funded primarily by the U.S. Agency for International Development. To my immediate right is Diz Locaria. Diz is a member of Venable's Government Contracts Group, but really it has to be an honorary member of our nonprofit group because of all the work he and his colleagues do with us in this area. His practice is focused on assisting government contractors in all aspects of working with the federal government, and as I said, he works with many of our nonprofit clients on federal grant and contract compliance work in advocacy and defense and everything else in between. He's represented clients before various federal agencies, including DOD, the GSA, Department of Homeland Security, Small Business Administration, EPA, and others. He has extensive experience in client counseling, including assisting clients with the nuances of becoming government contractors and implementing appropriate systems and methods to achieve and maintain regulatory and contractual compliance. You're going to really enjoy the program from both Stephen and Diz here today. A few housekeeping matters. Handout materials. So those of you who are here in the room have a printed booklet that has a printed copy of the PowerPoint slides from today, as well as some additional articles and other resources that we have put together on these topics. For those of you on the phone, you should have been emailed a copy of the PowerPoint presentation, and all of you will receive an email tomorrow that contains the PowerPoint presentation, the handout materials, and a recording of today's program with a synced PowerPoint presentation, which you should feel free to share with colleagues or others who might benefit from the program. And as you know, all of the recordings of all of our monthly nonprofit legal seminars and webinars are posted on our website. On the very last slide, you'll see a link where you can easily find that list of all the recordings along with all of our other publications on our website. In terms of questions, we have decided to take questions throughout the program today. For those of you here in the room, raise your hands. I'll call on you at the appropriate time. I might, on occasion, ask you to wait a minute while we let our speakers kind of continue the train of thought. We'll, of course, repeat the questions for those of you on the phone so you'll be able to hear. Those of you on the phone, of course, you can't raise your hand, literally, but you can pose questions to me using the chat feature on the webinar software. I'll be manning the laptop at the front of the room, and we'll pose questions to our speakers at the appropriate times. let's see, anything else? Yes, we have 2 upcoming programs scheduled that I wanted to announce. The next one on March 13th, Preparing an Online Social Media Policy, the top 10 legal considerations for your nonprofit. This one may be a record in terms of how quickly we got people to register for this. Within 24 hours of sending out the initial invitation, I think we had 250 people sign up so far between in person and on the phone. We do max out in the room on occasion, not often, but on occasion. This may be one of those, so if you want to attend in person, be sure to register sooner rather than later, but we have unlimited capacity on the webinar portion. That's going to be a terrific program, and we're going to tackle both employment-related topics with one of our employment lawyers who works regularly with our nonprofits in the area of social media, and then non-employment-related issues like copyright, trademark, defamation, privacy, et cetera. Going to be a terrific program. I mean, it's going to go far beyond kind of social media legal issues 101. April 16th is our program after that, entitled Public Policy and Politics, Compliance Tips for Your Nonprofit's Advocacy and Electoral Efforts. In that program, we're going to be covering issues that are relevant to both 501c3, C4, and C6 organizations. We're going to be covering not only tax issues, but Lobbying Disclosure Act issues, FEC, Federal Election Commission related issues, congressional gift and ethics rules, and kind of everything in between. I think it's going to be a terrific program. 2 of our really talented speakers in this area are going to be leading that seminar. So that's for upcoming programs. With that, we're going to get things started and try to wrap up by 2 o'clock Eastern. Our speakers are going to be kind of bouncing back and forth, covering the top 10 pitfalls for you here today. And with that, I'm going to turn it over to Stephen to get us started. Stephen?
Okay. So the first slide is failure to understand. Thank you, Jeff. Sorry about that. Understanding the difference between acquisition and assistance, I think, is really critical to understand, because the type of award instrument utilized for both are considered very different legal instruments in the government world. And I think whenever you're working in the government contracting arena, it's very important to understand the obligations that you're taking on and understand the difference between a contract and a grant. And so Title 31 of the United States Code provides specific guidance to federal agencies on the type of award instrument to use and when to use it. So let's start with acquisition. When the intention of the procurement action is to actually go out and procure goods and services for use or direct benefit to the federal government, the government's always going to use some form of a contract. So that could be a cost reimbursable contract, a firm fixed price contract, time and materials contract. There are many different types of contracts that the government can select from based on the type of procurement that they're doing. And contracts are governed by the Federal Acquisition Regulations, which are codified in Title 48 of the Code of Federal Regulations. The Federal Acquisition Regulations can be supplemented by the federal agency that has contracting authority. So, for example, you could, if you're working with the Defense Department, you may also be subject to regulations contained in the Defense Acquisition Regulations, or the DFARS, or say with the United States Agency for International Development, their equivalent being the ADARs. The FARs are quite rigorous and very detailed. I think they do require a certain level of sophistication, both on the part of interpreting and applying the terms and conditions that you're going to be subject to, but also in terms of the organizational systems, policies, and procedures that are going to need to be in place to ensure that you can adequately perform on a contract. Assistance, on the other hand, is when the purpose of the award instrument is to promote or stimulate a public purpose. The government is going to use either a grant or a cooperative agreement. And I think the principal distinction between a grant and a cooperative agreement is the level of government involvement. On a grant, you're going to have very minor government involvement. On a cooperative agreement, you're going to have substantial involvement. And that substantial involvement will be clearly articulated in your actual cooperative agreement, so you understand clearly what the government intends to, how their involvement is going to play out through implementation. Unlike contracts, grants and cooperative agreements are subject to the regulations contained in the Code of Federal Regulations. I think the Code of Federal Regulations is much more easier to read, easier to interpret, and easier to apply. I think grants and cooperative agreements are quite a bit more flexible, but by being more flexible doesn't mean that they're any less regulated than contracts. The federal government gives out approximately the same amount of money annually in both contracts and grants and cooperative agreements, and both are taken very seriously. So it's important to understand the difference of when you're using a contract versus a grant or a cooperative agreement, and the requirements that are that you're held to in performance under either of those award-type instruments. So some of the other distinct differences between a contract and a grant would be the legal concept of default. On a contract, if you don't perform, there are going to be both contractual and legal remedies that can come to make you perform or to hold you accountable for the fact that you did not perform. On a grant or a cooperative agreement, it's more of a best effort approach. You're going to apply your best effort to achieve what generally are going to be mutually beneficial goals and objectives. And if you fail to achieve those objectives, there's really very little that the federal government will do. The most likely outcome is you will not receive additional grant funding for that type of program. Other distinct differences that I think are really important to understand would be like payment. With a contract, federal contractors are expected to finance the working capital required for contract performance. Under a grant or a cooperative agreement, you can negotiate advance payments and receive money so that you have working capital available to perform. Involvement is another big area. Under contracts, there's going to be very major involvement by the federal government, and they're going to define that involvement through the terms and conditions contained in the actual contract. On a grant, there's going to be minor involvement by the federal government, and as I mentioned earlier, on a cooperative agreement, there is substantial involvement. And one final difference that I'd like to draw between them, because I think it really helps to understand the true differences between these two procurement mechanisms, is termination. On a contract, only the government generally maintains the right to terminate a contract. And if the contractor terminates, they may well find themselves in contract default. On a grant or a cooperative agreement, the recipient does have the right to terminate an agreement at any point in time with really no sanctions for the fact that you terminate. So to me, those are the principal distinctions. A contract's going to always be used when the government is actually acquiring goods and services, and a grant or a cooperative agreement are going to be used when the government is supporting or trying to stimulate a public purpose.
Stephen or Diz, do you want to just briefly comment on some of the differences between a grant and a cooperative agreement?
The primary difference is substantial involvement, Jeff. On some of our cooperative agreements that I have the pleasure to administer, some of those, the substantial involvement might be defined as the requirements to get agreement officer approval prior to purchasing non-expendable equipment or for international travel, or they may actually want to have programmatic input into the selection of themes like for enhancement workshops that we may be running for students that we're supporting.
The primary thing to consider versus a grant versus a cooperative agreement is really in the name. Where cooperative agreement, you're actually working as much more as a partner with the agency than in a grant. As Stephen mentioned, a grant, there's very little involvement with the government. You have usually a very general charge whereas a cooperative agreement is a much more involved process with the agency, and it should be viewed more as a partnership than a grant.
So the cooperative agreement is a contract then, or is that a grant?
It is a form of a grant.
The question was whether a cooperative agreement was a contract, and no, it's a form of a grant. Yes.
We should clarify that when we use the term contract versus grant or cooperative agreement, that's as Stephen just spent the last 5 minutes explaining, it's a critical difference between acquisition and assistance. But we're not using that term, the term contract in the former, in the classic legal term. Because in all of these, we are talking about binding agreements that impose obligations on your nonprofit organization in any event. So don't think just because it's a grant, that doesn't mean that you're not obligated to do certain things, and that you're not contractually obligated, because you are.
Good point, Jeff. The second point that we're going to address today is, and Stephen touched on it, is believing that grants and grant recipients somehow are subject to some greater compliance latitude. As Stephen also mentioned, the government allocates funding about 50-50 with respect to contracts and grants. And while they're under different regulatory schemes, it's important to keep in mind this is still federal dollars, and the federal government, which wields a very heavy club for noncompliance, is just as interested in compliance on the grant front as it is on the contract front. A lot of times you'll hear about, toilet seats that cost $15,000 by the Department of Defense. Those make the headlines, but make no mistake that grants are as heavily regulated, and in some regards I would say more heavily scrutinized than contracts, because the regulations are different and they're not as complex and exacting, I guess, as the FAR. So in that regard, it's just as important that your compliance programs for grants and cooperative agreements be instituted as you would in the federal contract sense. The Department of Justice and OIG offices are still out there looking at grant and cooperative agreement recipients as well as contractors. So the notion that somehow it's a less regulated industry or less enforced industry just doesn't apply. Title II of the CFR, which deals with grants and agreements, has a specific section dealing with suspension debarment for grant recipients, and that is a government-wide effect. So if you would be debarred at the contractor or at the grant level, you would also be debarred at the contractor level, and vice versa. The government wants to be crystal clear with folks that compliance is across the board. And too many times I have clients that say, well, it's just a grant. Well, there should be no well. It's just no different. Sometimes grants have more loose language. Like I said before, the statement of works or the purpose can be broad, and organizations sometimes take liberty with that. You have to be very careful with that. Broad statements and broad purposes are there for a reason, but you can also be hung by your own leash. And so it's important that you be mindful of what those purposes are, whether your purpose that you're effectuating is reasonable and is not so tangential, you're so far removed from the initial concept of the grant that you end up finding yourself out of scope. We oftentimes have to deal with organizations and grantees that find themselves on the wrong side of the scope issue, and they're using funding for something the government never contemplated. One last point on this is that one thing to keep in mind is that to emphasize the enforcement side of it is that the Defense Authorization Act of 2013 provides new whistleblower protections. One of the things about this Authorization Act is that it extends to grantees as well as contractors, affording them, whistleblowers, much more latitude and protection when it comes to things like gross mismanagement of funds. So it's important that organizations that are grantees realize that while they may not be contractors in the sense that a big C, I guess, that their enforcement is going to be just the same as you would if you were under the FAR.
Diz, we have a question from actually one of the clients with whom you work pretty frequently on compliance issues, so maybe it's not good that this is coming from her, but it seems to me that some agents, and I know this is not her organization, it seems to me that some agencies are viewing grants as not only requiring best efforts, but results. And I think implying that some organizations are viewing it the opposite way, as you said. Are you seeing that, and how do you combat this creep? Any thoughts on that?
Yeah. So in terms of agencies requiring results instead of best efforts, that's nothing new. A lot of times, well, we've seen recently that the government has gotten extremely aggressive in the past 3-4 years with respect to enforcement and taking action for contractors and grantees when they feel that there's been waste, fraud, and abuse. And so while you may be making best efforts, sometimes the government will say that's not enough. Now, my position is, yes, it is. But that's why I get paid to do what I do, is defend companies and organizations that have taken their best efforts in terms of compliance. Now, at some times there's strict liability, and there's certain standards that you have to meet. So best efforts may not satisfy everything. But certainly best efforts are a great defense to a situation, and I would advocate to always take best efforts, even in a situation where compliance could be nearly impossible.
Okay, thanks. Stephen, you want to take the next slide?
Sure.
Yeah, we have a question in the back.
So normally, under assistance agreements, the recipient of the funding has no standing to sue, as they would in a contract. But there was a case in the Court of Claims that was the National Science Foundation where the recipient was given standing to sue as if it were a contract if the grant looked itself like a contract, offer acceptance and consideration and signed by somebody with authority to sign a contract. So my question is, in principle, how often does that distinction between an assistance agreement and a contract get blurred in light of this case in several years?
The question was essentially, there's a case at the Court of Federal Claims that deals with interpreting a assistance agreement as a contract for standing purposes, and the question, as I understand it, is how often do the two get blurred on a legal basis or just a practical basis? Right. Okay. Often, and oftentimes, almost all the time. Partly because, as Jeff mentioned, these are still contracts. A grant is still an agreement that obligates the parties. And so oftentimes contracts is used broadly or narrowly, and it's confusing. And that's why I think the first slide, number one, is understanding at the outset what you have, because it does define your rights. And so knowing at the outset that you have an assistance agreement, either a grant or a cooperative agreement or a contract, is key. And so I just can't. There's a number of fact patterns where things get blurred, and so it's important that the parties just try to remain very clear on what their rights are under what type of agreement they have.
Does your question really relate more to what rights does the organization have to bring, what sort of enforceable rights does the nonprofit organization have to bring some kind of a lawsuit or to pursue some other recourse if it believes it's not having its end of the bargain fulfilled by the government?
Well, that was the subject of this case in the Court of Claims. But on the other hand, in terms of exposure, that could come back to the other way, liability against the warden because it looks like a contract, even though it says grant on the top.
Right. And I mean, I've seen situations where it's clearly a grant, and everyone knows it's a grant, but the Department of Justice, which doesn't understand the difference between a grant and a contract, will apply terms that are typical to a contract. So the blur, we see it often. So it's unfortunate, but it's due to it's such a complex environment that it really gets confusing.
I actually have a question from the webinar that's a great follow-up to this. It says, if the organization does not believe the work falls under a contract definition, but believes it should be more appropriately characterized as a grant, does the organization have any recourse against the federal agency?
My answer to that is all about posture. When do they believe that? If they believe that at the outset, before anyone submitted any proposals or information, if it's characterized as a contract when it should be a grant, at that point you should approach the agency, whether it's through the Q&A process of a grant or of contract, and address that issue, that this is more akin to a grant than a contract. Is this really what you mean to do? I'm going off on a little bit of a tangent, but one of the big problems that the federal government is experiencing right now is the education of their workforce. Oftentimes, contracting officers, grant specialists, they don't know all the nuances of everything. And so work with the government and try to help them understand everything. It will make your life much easier if you guys are all on the same page at the outset.
Okay, Stephen?
Mm-hmm. So funding issues. This is something that I think is really imperative that organizations consider at the very outset when they're deciding whether to pursue an opportunity with the federal government or not, specifically as it relates to organizational cash flow. As I mentioned on the first slide, when you're operating with a contract, the contractor is expected to finance the working capital. And I think it's important to really carefully look at the budget that you've prepared for that program and look to see what your cash flow requirements are going to be for, say, approximately the first quarter, and be comfortable in knowing that you've got adequate reserves to be able to finance that working capital. Under a contract, you're only going to be paid according to the payment provisions of that contract. Generally, you can invoice on a monthly basis, but the government will take up to 30 days to pay you. So right out of the gate, you're looking at potentially 2 months of funding. And then you've got to factor in other contingencies, like when the government may challenge certain costs, and so they come back with questions about those costs. Generally, they will withhold the payment on those question costs until their questions have been resolved satisfactorily. So you just got to be prepared to have adequate resources to be able to fully ensure that you have the ability to perform under the contract. Under grants and cooperative agreements, you really have multiple options. You can negotiate advances. I think when you're dealing with advances, you're dealing with a higher administrative level of effort, and I think it's important to factor that into your decision when you're making that determination of whether to bid or not. Or you can seek reimbursement after you've expended your own resources. There are 2 ways to do this. You can establish a letter of credit with the federal agency that you're working with. Most of the federal agencies that I work with all avail themselves of the payment management system, which is administered by Health and Human Services out in Rockville. Another thing to consider about advances is that the government wants to limit advances to its recipients as close as administratively possible to the actual disbursement date of when you're going to make these disbursements. So on our grants with the State Department, for example, if we were receiving advances, we would have to liquidate those advances within a period of 3 working days. So, as I said, your administrative level of effort is much greater because you're constantly replenishing your advance. When you're doing reimbursements, you can reimburse yourself as soon as you have expenses. So you can draw down against your letter of credit at any point once you've incurred those costs, which is what my organization does, because I think we find it easier just to use our own resources and then reimburse ourselves like on a weekly basis. It gets further complicated, and especially in today's environment of when you're operating under a continuing resolution, as we are today. So just like the federal government wants to limit the advances to their recipients, the federal government is also limiting its advances to its own federal agencies. And all awards, whether they're grants or contracts, are awarded subject to the availability of funds and subject to appropriations. So if the federal agency hasn't received their funding from the Treasury, they can't give you money. when we're operating under a continuing resolution, and I've been in my current job now for starting 14 years, every start of the fiscal year we find ourselves financing 1 to 2 months of federal activity on all of our agreements, and that adds up to quite a bit of money. So if you're a large organization and you have cash flow, you may be able to sustain that, but it's not the intention of the federal government to have the recipient finance its programs. And so when you're operating under a continuing resolution, I think it's really important to establish a very solid working relationship with your agency program staff and the contracting staff so that you can get your estimated cash requirements for the period of that continuing resolution to them as soon as you have it available so they can identify funds, make it available, and have it obligated to your agreement so you at least have the ability to draw down on resources. And I think it's also really important to understand the payment provisions and understand them very clearly in your agreement. So you need to look at contract type. Is it a cost type arrangement where you're going to be reimbursed for actual cost? Is it a cost plus fixed fee contract where you need to be aware of limitations on fee? When you reach 80% of payment of the fee, the government's going to withhold payments of the balance because they want to use that as a carrot on a stick to make sure that you fully perform and satisfy all contractual deliverables before they're going to pay the final amount. Finally, one thing that I've always noticed throughout my career is people failing to understand the difference between the estimated ceiling in an agreement and the actual funds obligated. So as an example, if you were awarded a $15 million cooperative agreement to support a certain activity and the contracting officer obligated $5 million, you really only have $5 million to spend. The difference, the $10 million, is a backlog. The government intends to fund it subject to the availability of funds, but there are no guarantees. They are making no commitment to you. So you only really have the ability to spend up to that first $5 million in the example I've given. After that, you're operating at your own risk. The government has no obligation to honor any reimbursements or things. So you want to pay very close attention to your expenditures against your obligations to make sure, again, that you're working with your program contacts and your contracting officer to have additional funds made available prior to running out of that obligated amount.
Stephen, I have a question for you. It's kind of the reverse of what you just said. As we know, and I know it's happened in your organization quite often, sometimes you don't actually run out of funds, but the opposite happens where you get toward the end of a program and you haven't spent all the funds that are available to you under the contract or the grant or a cooperative agreement more commonly with your organization. In those situations, can you just explain to everyone kind of the process for trying to get an extension to that agreement, to that grant, to whatever form the award is, in order to be able to utilize those funds, say, in the subsequent fiscal year, and what sort of limitations are there on that?
Okay. I think to answer that question, it's a really good question. There are really two things you have to consider. I think the mindset in the federal government of use it or lose it has changed. The government really would like to recover unused funds. So when you go in to request a program extension, a no-cost extension to your agreement, you have to have a very solid and justifiable programmatic reason for extending that agreement. The government, in my experience, at least with agreement officers that I work with, very rarely will it extend in a cooperative agreement just because you have residual funds that are remaining unspent. You're going to have to tie that to a very specific programmatic objective of what you're going to accomplish additionally during that period of the no-cost extension.
So you mean, for instance, if the program is kind of continuing, the next year's version of that program is continuing, is that an example of something where you might have a more justifiable case for taking residual funds and applying it to the subsequent year of that same program?
You mean if it's continuing but under a separate agreement?
Right, right.
No, I think if it was continuing under a separate agreement, they would prefer to deobligate those funds, bring them back to the agency, and it's their determination is to utilize those funds as obligated against the new instrument or whatever agency requirements they have. Maybe they have to return them to Treasury.
Okay, and one final kind of follow-up question. And you may not be aware of this off the top of your head, but what sort of statutory or regulatory restrictions are there on the ability to extend those agreements and utilize residual funds in subsequent years? And how far out can you go? Are there time limitations on when that money has to be spent, et cetera?
I think partly it depends on the source of funds. Like I know economic support funds, I think, have a limitation. I believe it's 7 years. I think under normal grants and cooperative agreements, it's generally 5 years. And I think under contracts, there are, in the database that has the CFDA numbers, the Catalog of Federal Domestic Assistance, you can generally find the authorizing legislation that came out of the Appropriations Subcommittee that states how long those funds are available.
We do have a question here. Sorry, we have a question here from the webinar. Have you had any experience, for example, end of the fiscal year, closing down a payment system to change computer systems, where federal agencies are not paying attention to the advance close to expenditure rule and want to, sorry, I'm having trouble reading this, fling the money out the window fast and in large chunks, even though they know that the recipient will not be obligating the money quickly? If we want to take a pass on that question, I'm not going to call her out by name, but she can follow up a little bit later, because I'm not sure I quite understand the question either. All right, we'll take a pass. We'll follow up with you later. All right, Diz?
Okay. Number 4 on our pitfalls is understanding the applicability and scope of certain OMB circulars. There's a lot of confusion, I find, with respect to these circulars and how organizations view them and how they apply them. There's really 3 preeminent ones that we'll discuss, and we'll discuss it at a pretty high level because we could talk all day about these circulars. But A122, in my mind, has very limited applicability and scope. It applies to all nonprofits, and it applies to cost-based type agreements. It doesn't apply to fixed price type arrangements. It also does not apply to a profit or fee that's associated with the arrangement. And the thing to consider, though, is that the FAR, the Federal Acquisition Regulation, which applies to contracts, also kicks in or pulls 122 in for nonprofits on cost-based contracts. So even though you have a contract, you may not think A122 applies to you, but if you look at the FAR, it sends you back to A122. And that's, I think, something that organizations, nonprofit organizations, sometimes overlook because they believe they have a contract that they're under the FAR, but then they fail to notice Part 31, which sends them back to A122. So it's important to recognize the applicability of this, that it also does not apply to the cost or to the profit or fee for nonprofits. Nonprofits, just like any other organization, are entitled to gain a profit or fee for the work they do. It's the inducement for them to do it. So please keep that in mind. Now, with respect to A21, which applies to educational institutions, it's similar to A122 in that it, again, applies to at all levels, so as a subcontractor, which I didn't mention on A122. But, again, as a subcontractor, it still applies to the educational institution, just as A122 applies to nonprofits. And it also applies unlike A122, it provides a guide for price, for fixed price arrangements. So it's a little bit different in that regard. It's the same in the regard with respect to profit and fee. Again, it doesn't apply to profit or fee. And then there's A110, which applies to nonprofits, educational institutions, and hospitals. A110 is a little bit different than 21 and 122 because it's not dealing with cost principles. It's dealing more with administrative issues. So it's important to recognize that A110 will apply to you irrespective of whether A122 or A21 applies. So it's important to keep these in mind. It can get confusing. As you can see, I trip over the numbers all the time. And they're all codified at Title II of the CFR in Part 200 if you need to pull those up. Now, we can, again, talk all day about the specifics of each one, but for our little touch here, it's a little difficult to get into that. Now, also keep in mind that there is a rewrite that's going to affect these circulars as well, and that should be coming out any time now. So there'll be more to tune in to in the future, and I'm sure we'll be sure to address it within the nonprofit group here at Venable.
Yeah, we'll be certainly putting out some kind of an alert on the revisions to those circulars. And by the way, I forgot to mention at the outset that thanks to Diz's initiative and his colleagues in the government contracts group, we're going to be putting out, and put out our first issue already, a regular newsletter called Federal Grant and Contract News for Nonprofits, kind of updating everyone on new developments and whatnot in the area. So be sure to subscribe to that newsletter if you're interested. But Diz, back to particularly A122 and A110, can you maybe take a step back and just so folks really understand the differences between them, maybe just give, or maybe Stephen too, an example or two of what A122 generally applies to in terms of specific examples and versus 110.
Yeah, and Steve, feel free to jump in. A122 applies to cost principles. So as you're developing a cost-based arrangement, you need to consult A122 in terms of what costs are allowable, what costs are not allowable, what you can factor into your arrangement. A110 does not deal with cost principles. A110 is more an administrative framework, telling the organization how it needs to comply with the grants and terms. It has basic administrative type regulations. I don't know if you want to add.
Yeah, A110 is the uniform. Sorry. The OMB Circular A110 is the uniform administrative requirements for managing grants and cooperative agreements. And it basically follows the life cycle of the award. So it starts with pre-award, post-award, and closeout. It's going to define the standards for your financial management systems. It's going to define the standards for procurement under a grant or cooperative agreement. It's going to lay out for you the various instances when you have to go to the grants officer to request an amendment, and there are like 4 or 5 specific times, like absence of key personnel for more than 25% of the grant. They want you to come back and make sure they're aware of that so that new staffing can be made available. A122 establishes the basis for determining cost under grants and cooperative agreements. It also goes into an extensive treatment of how nonprofits would calculate their indirect costs, and it gives you 3 different manners in which you can calculate your indirect costs for use on federal awards.
As you can probably tell, I know some of you in the room and participating on the webinar are new to the kind of world of federal grants and contracts. And as you can probably tell already, it's not a world that you want to enter lightly. It's a world that you have to enter being very cognizant of these external requirements. You have to look, and I think we're going to talk about this in a little bit, but you have to look far beyond the 4 corners of the document that you've signed and that the agency signed to look at things like 122 and 110, because it's going to require you to put certain systems and controls and accounting and other things in place in order to be able to comply with these requirements. We work with organizations like Stevens and others to do extensive training for staff on how to comply. In fact, we're going to be doing some trainings for you guys on 110 and A122. We do this for lots of organizations. Internal trainings get done. It's very, very important because you have to comply with all these requirements. Your external auditors also come in and sometimes will do audits on how you're complying with these various requirements. So it's something that you really need to become knowledgeable of. You don't have to go out and get a law degree, fortunately, but you do need to. In fact, people like Stephen know more about this stuff than a lot of lawyers in this area, but there's just no substitute for that.
Okay. Number 5 on our list deals with failing to maintain accurate time cards and other records. Now, as Jeff just mentioned, part of being a government contractor, grantee, cooperative agreement participant, is maintaining systems of compliance. One of the major systems that we find that organizations might be deficient in are with respect to time and labor charges. It's an easy area to find yourself running afoul because it applies to every individual within your organization who's working on a grant or a cooperative agreement and on cost-based contracts. So it's imperative that this information, make it to every individual within the organization, which is a difficult and sometimes seems like an insurmountable task, but it's essential. The accuracy of time cards and reporting and invoicing is really of paramount importance because estimates are not allowed. What the government, when it's paying for its services, it's paying on a cost-based grant, cooperative agreement, or contract. It's paying for the cost. It's not paying for what you think the cost is. It's paying for the actual cost. So it's absolutely important that quotas and goals not be the benchmark to how one records time, but rather the time actually spent. Now, a law firm works in a lot similar fashion, and what we found within the four walls of Venable here is that contemporaneously timekeeping is key, and I can't impart that enough on my clients, much less my colleagues. In fact, we had a meeting not too long ago where our managing partner explained to us the importance of not waiting weeks to record your time. You need to record your time immediately. You're going to forget what you did. So it's important that be done as frequently as possible, and really that there be a system in place to allow your employees to do that within the organization. The system can be as important as the actual conduct of your employees. It needs to be understood. It needs to be as simple as possible, and it needs to be accurate in how it's set up. A lot of times you may have an agreement with an agency, and you have various components of that agreement that you need to itemize. Your system needs to be able to handle that. You need to be able to handle multiple agreements with one agency. I recently had a client who's been a client for years, and they just brought to me the fact that, we always just put it all under this one. I was like, we all put it under this one code for this one agency, and that's just, you're going to need to split it up by agreement, by contract, whatever it might be. You need to break it up individually, and those are things that taking the time at the outset of any agreement is going to be key to setting those up, because what you don't want to do is have to go back and clean up the system after the fact. A lot of times people want to cut corners to save costs at the outset, but at the end of the day, if you're coming back with inaccurate numbers, which represent false claims to the federal government, it doesn't need to be intent. It can be something as mere as reckless disregard, that you weren't careful. It can cost a lot more to the organization to set up those systems or to clean those systems up after months and months of inaccurate timekeeping. As I mentioned, false claims, false statements, oftentimes time cards have to be certified. When they are certified, that is a statement to the federal government that it's true and accurate. So it is imperative that these systems be correct, and otherwise the repercussions can be severe, not only civil, potential criminal if there's intent. Suspension, debarment can ensue simply because you weren't careful enough in setting up your systems. It doesn't have to be malintent. So I don't know, Stephen, if you want to add anything.
No, I think the OMB Circular A122 is quite specific on timekeeping. It has to be an after-the-fact determination based on time actually worked, and as Diz pointed out, it's got to be allocated as time actually worked to a specific cost objective, and the cost objective being a particular agreement that you've been working on. And they do have to be approved, and they have to be approved by somebody who has reasonable knowledge of what you're working on so that they can make a determination that it's accurate and complete in approving your time card. At my organization, we're required to keep our time on a daily basis in 15-minute increments. So we act much like a law firm in the way we keep our time, but timekeeping is of paramount importance, and I know sometimes keeping a time card is kind of foreign to many people, but it's extremely important.
Yeah, just one comment first on Stephen's question. I know IIE does a terrific job of training all new employees on time card practices. Watched a video that you guys have put together that all new employees have to watch that walks in detail through the timekeeping process, and all supervisors are very rigorous at kind of cracking down on their staff to make sure that time gets entered contemporaneously. Just estimating what programs you worked on, things like that, it just doesn't fly, and the consequences can be severe. And the offices of Inspector General at the various agencies take this stuff very seriously and will come down very harshly on grant and contract recipients. Stephen, do you want to speak to something that we had discussed several weeks ago, kind of the issue of, you referenced this just now about, can we keeping your time, it's not just about saying I worked on this program, but sometimes the agencies want you to really break it down by subcategories, this subprogram, and sometimes that can become fairly daunting. And just in your experience, what's the best way to deal with, say an agency that's pushing for too many, numerous multiple program codes and subcodes and whatnot, where it just becomes too daunting for your staff?
Well, I think it's primarily a function of your accounting system, and if you have a good cost-based accounting system where you can set up cost centers related, we have a number of contracts, Jeff, that directly address this because they're CLIN-type contracts, and we have to report back on the effort by various CLINs. And by CLINs, I mean contract line item. This is a DoD cooperative agreement that we have, and it's a challenge. But they do require us to report our time, and it ends up being a function of the cost centers that we establish within our accounting system and how we track our time and other direct costs as well that are attributed to that particular activity under a contract.
Let me add a point to that really quickly. Oftentimes, the government will ask you to itemize things, and it's not required by the grant or the contract. That's a dangerous area to play in because you may not have set up your systems to do that because you're not required to do that. Don't fall into the trap of providing that information without some qualification, okay? Because what you're ultimately going to provide is an estimate because you don't know contemporaneously, because what will happen is an IG will come and say, okay, they'll interview each employee and say, did you work X hours on X day? When did you fill out this time card? I filled out this time card a year later when the contracting officer was asking for it. That's fraught with danger. I can't impart that enough. So it's important that if you're not required to do that under some like a fixed price type arrangement, that you push back with your contracting official, and that if they ultimately demand it and you're trying to satisfy your customer, which is understandable, that you do so in a manner that's qualified to protect the organization, that these are not required under the contract, and we are not certifying to the accuracy of this. This is estimates only based upon your request. Because I have seen companies fall into that trap and organizations fall into that trap where they are pushed into providing breakdowns of individuals' time on fixed price arrangements, and you just need to be very careful in those situations.
Okay, question over here.
In regard to contemporaneous timesheets, what's the definition for contemporaneous? Do they have to be filled in? Can you wait to the end of the week? Or if you have a biweekly payroll, can you wait to the end of the biweekly payroll? Can you wait to the end of the month? How far can you go before you run afoul of that requirement?
And let's be sure to answer that both from a best practice perspective as well as from kind of an A122 perspective.
Mm-hmm. I think the very bare minimum requirement is keeping time cards on at a minimum a monthly basis. I think doing it more frequently is certainly preferable because unless you're keeping some kind of secondary track of your email, like some people use their Outlook calendar, some people keep a daily planner where they keep track of their time. I think if you're going back to prepare your time card after a whole month has transpired, you're going to have a really hard time remembering what you did on the second day of the month. So I think the longer it goes, the more tricky it's going to get in terms of having really solid evidence that that's actually time worked, unless you're keeping secondary records. And if you're keeping secondary records, you may as well be doing your time card.
In terms of best practices, I mean, we recommend that companies at a minimum do it on a weekly basis, but even more emphatic on a daily basis, that at the end of each day you enter in your time. Because that's really I mean, people often forget what they've done on Monday when it comes Friday, or they're just trying to get out of the office on a Friday afternoon. And so we found the best practice really is at the end of the day or the beginning of the next day to do that. But in terms of what is contemporaneous, it's a little fuzzy.
But whatever your organization determines is reasonable and appropriate and legally compliant, you want to make sure that you inform all your employees of that and that you're regularly enforcing those rules. Mm-hmm. Question over here.
What level of enforcement what is the step? How can you...
For the organization?
So the question is what level of enforcement is appropriate? I mean, I can answer just generally, just like we talk about with all other sorts of rules. You know, for instance, we had a seminar, I think it was last month's seminar, was on exempt versus non-exempt employees and what's compensable time. We were talking about there was an example given of an employee. Actually, no, this was a real client situation that came up where they had an employee who was repeatedly a non-exempt employee staying in the office until about 8 o'clock at night, sometimes working, sometimes not, waiting, I think, for her husband to get off work so she can meet him and then go home. And the question was, you know, is that time compensable? Of course, the answer is yes, even if the person's not being asked to stay late, it is. But the question was, you know, what can we do about it? And you are absolutely not only allowed to, but you should be disciplining employees who are not following your basic rules, whether it's a non-exempt employee working when they're not authorized to work, or whether it's any employee who's not keeping time cards according to your practices. I mean, I know even at Venable, we're doing it for different reasons. Our time cards and timesheet system, you know, but we have enforcement here. I think if you miss the timesheet deadline, you know, 2 or 3 times in a row or something, 3 times in a year, then you lose the ability to get direct deposit for your paychecks. You know, and then if it continues more, there can be other sanctions. You know, different organizations can take different remedies, but you have to do something. Yeah, one more question. We're going to move on.
When you're working on a grant situation and also the general sheet that's been generated, often it's organic. In other words, when you're thinking about it, it's not a left-brain process where you're just working 4 hours or 6 hours or 8 hours. You're actually working around the clock for different cycles. So then how do you, I mean, doesn't this presuppose the mechanical kind of external kind of offer? So how do you put that time? I mean, so how do you even record the time? Isn't it a false assumption in the 21st century to require that?
Biz, you want to take that?
Yeah, I think the question is how do you account for your time when it really is an around-the-clock effort in this environment, in these days? I mean, I think 20 years ago, jobs were much more 9 to 5. You didn't have BlackBerrys. You didn't have mobile communications like you do today. And so it's certainly created a different workforce and a different work environment. There's no good answer because the federal regulations haven't caught up. They haven't caught up to the fact that companies and organizations work around the clock now and that you have mobile devices. Certainly, you know, legitimate efforts spent on any grant or cooperative agreement or contract should be recorded. But as you get more and more, I guess there has to be some reasonableness to it. You're in your shower, you know, thinking about a number of different things and something crosses your mind, you know, there's got to be some reason to it. Actually, the movie The Firm with Tom Cruise, John Grisham book, had a thing where I think Gene Hackman, this is something I remember because I'm a lawyer, Gene Hackman told, you bill your client for everything. You're thinking about him in the shower, you bill him. You bill him, you bill him, you bill him. Well, but there has to be some reason. And at the end of that movie, the firm got nailed because it overbilled. So there's the kind of the moral to the story is that I think it needs to be some amount of reasonableness to it, but there's no good, clear answer to that question. It really has to be what you feel is reasonable work spent on that arrangement.
You know, sorry, we're going to have to move on. We have 5 more pitfalls to cover in 30 minutes. Yeah, but come up afterward and we'll talk more. All right, let's move on to number 6.
Okay. Taking advantage of a post-award conference, especially if you're a new entrant into the federal contracting arena, it's just a really wise idea to do. But you have to ask for it. And so when you receive your agreement, you would want to read that very thoroughly and very carefully and be honest with yourself. What you don't understand, jot down. And then request a post-award conference with the agreement officer, so that you can go through all your issues and make sure that you're very clear in understanding what's going to be expected of you. Or if there are certain clauses that you're not sure why they're in there, now's the time to ask, to get it directly from the agreement officer. Some of my agreements limit things to like 2 working meals are allowable. Well, what's a working meal? These are all legitimate questions that you want to go over with your agreement officer at the outset so that you're very clear and you don't find yourself getting into trouble later. It has multiple advantages as well, because I think it's always helpful to put a name with a face, and establish a good working relationship. It allows you, like if your agreement officer has to provide grants officer approval in advance of any subcontracting or any international travel or any procurement of non-expendable equipment, you can sit down and discuss with them, how much time are you going to need to make a determination so I can factor that into my planning. A lot of agencies will say, give me 3 weeks notice prior to international travel. And that's really advisable, because hopefully then you're going to have the agreement officer's approval still with sufficient time to purchase your tickets. I've had it go up to the very day of departure, but it's mostly because people have waited to go and request approval. And so sitting down with the agreement officer up front to look at the requirements that you're going to have to be dealing with the agreement officer and working out reasonable expectations will come back to benefit you numerous times throughout the agreement. So I think it's important to avail yourself of that, but generally you have to request it. But if you do request it, every federal agency that I've had the privilege of working with has always been very good about offering post-award conferences, so by all means take advantage of it.
One thing I'd like to add is, again, this goes to the concept of really your relationship with the government needs to be a partnership. You're providing them a service, they're overseeing that in some ways not, but the bottom line is you always want to take advantage of touch points with your customer, because should disputes or issues come up down the road, it's human nature for an individual who you have a relationship with to work that out, as opposed to someone you've never talked with. So you really do want to develop a relationship with your contracting officer or your grants officer. I can't tell you how many times I talk to clients and they come to me with some kind of dispute, some issue. Well, how's your relationship with your contracting officer, your grant officer? I hardly know him. That's not a good situation to be in, because you're never going to be able to really have a very good, your first interaction is going to be an adversarial one. You don't want that. You want to have a very good working relationship, and as issues come up, you work those out like any reasonable party would. So again, it's a chance for you to meet with your customer at the outset to get a better understanding of things, and it's really a touch point to establish that your organization is one that's trying to do the right thing, trying to help them, trying to build a partnership. And the government, that goes a long way with the government. So I couldn't impart it enough.
Okay, let's move on to number 7.
Okay. Failure to read the federal award thoroughly. This seems like a no-brainer, doesn't it? But I can't tell you how many times I have staff come to me and say, well, I didn't know. Well, they didn't read the agreement. And if you're not reading the agreement to fully understand the terms and conditions that you're required to adhere to, then my response to them is I really question how you can make responsible management decisions without knowing what you're required to do. Now, how do you read an agreement? Because they, take you all over the place. It's like one of those little puzzles that your kids play when you go to the restaurants with, help Macy find his way home. Well, that's exactly what it is, and I like to think of agreements as puzzles. When I first get an agreement, I'll read it through once very quickly, and then I will go back and I will take the parts that are incorporated by reference, and I will go read all of those. As Jeff pointed out earlier, on the cover sheet of most grants and cooperative agreements, they're going to have checked what's incorporated by reference, and you'll generally see the equivalent or the agency equivalent, their codification in the Code of Federal Regulations of the OMB Circular A110, A122, and one we haven't discussed today, A133, which is the audit principles for grants and cooperative agreements. You've got to read those thoroughly. As Jeff indicated, the OMB Circular A110, it's going to establish basic guidelines and principles that you need to have in place in terms of your very own organizational policies and procedures and your systems to be able to ensure that you can adequately, say in the case of accounting, accurately and completely account for all receipts and disbursement and expenditure of federal funds. It's a very important requirement when it comes to accountability. And then go back and read it again. And then you'll start to, little lights will come on. And each time you read it, you're going to pick up different elements and different things are going to reside with you better. And you're going to start to understand and appreciate why that particular reference was incorporated on that page, because now having gone and read what was incorporated by reference, now you're starting to get the real holistic picture, the full body of what's intended. I would read an agreement 2 or 3 times before I would ever go to a post-award conference. I read agreements so often that many of them I've almost memorized, because many of my grants and cooperative agreements, say with State Department, follow the same standard format. So I really have become very well versed with those terms and conditions, and likewise with the United States Agency for International Development. And it's not just enough for management to understand. All of your staff working on it have to have a very fond appreciation, because they're making commitments and obligations too, and you can't be everywhere at once. And so, at my office, when we're first awarded a major federal award, we require all staff working on it to fully read the agreement and consider the applications of the OMB circulars as it relates to their specific function within their job. And then we hold like a 2.5-hour compliance training on that specific award, so we can, much like a post-award conference, to address people's questions about, well, I kind of understand this, but what does this really mean, and how do I have to approach this, and what kind of documentation do I have to have for my files to adequately support the A133 compliance audit? They're really good questions, and I would rather entertain those up front than after the fact. So it's really important for everybody associated with that agreement to have access to it, to have read it, and to fully understand it, and not be afraid to ask questions. There are no stupid questions when it comes to understanding your agreement. And if you do this prior to your post-award conference, if you've requested one, you're going to come away with a very good working knowledge of that agreement. And then, I'm a little retentive, so I revisit things on a quarterly basis. I would constantly be revisiting it just to make sure that you're very clear about your obligations under that grant, because whether it is a contract or a grant, federal government takes it all very seriously, and you do not want to find yourself in a situation where you're being threatened with suspension and or disbarment because of failure to comply with your agreement. I think it's also really important to understand that the type of agreement, whether it's a cost-based agreement like a cost-reimbursable contract, or a firm fixed-price contract where you're really taking the risk on for performance at a price that you negotiated up front. So really understanding the nature of the agreement, the type of the agreement, and the terms and conditions of the agreement, I think, are just paramount importance to be a successful federal contractor. It's not rocket science. You really just need to read and understand and ask good questions.
One point to add to that as well is it's important to read the agreement, because if you're using subcontractors, subgrantees, vendors, a lot of the terms need to go down to them, need to be flowed down by law, but also to protect your organization. There's certain flow downs that are required, but there's also certain flow downs that just make sense for you to flow down because maybe they're taking the lion's share of that work, and that provision applies to that work, confidentiality provisions, insurance provisions. it's important to consider what needs to be flowed down before you enter into those subcontract agreements, because after you've signed that subcontract agreement, 9 times out of 10, those subcontractors are not now going to agree to new terms. So, it's important to read it at the outset so you can set up your contracting arrangements with your partners in the best manner for your organization.
All right, let's move on to the next slide.
Number 8 is misunderstanding the delegation of authority. And what we really want to impart here goes to this idea of the partnership with the federal government, reading your agreement. Your agreement will oftentimes stipulate who the contracting officer is and what their authority is, who the COTAR is or the grant specialist, and will designate what their authorities are. Those are codified oftentimes in your agreements. So again, reading the agreement is important because you're going to get a better understanding of what they can do with respect to that agreement. On a general sense, contracting officers, grants officers are the only folks that are authorized or warranted by the government to obligate the federal government, both in terms of performance issues and disbursement funds. Things that you hear from your specialists, who are 9 times out of 10 the person you have interfaced with most, they can't bind the federal government. Too often I have clients calling saying, well, they told us we could do X, Y, and Z. I'll dig into a case for a couple months and I'll find out that person is not even the contracting officer. That person's a specialist. They have no authority. They have no authority to interpret a regulation. They have no authority to obligate funds. And sometimes the clients don't even know that person's, I thought that was our contracting officer. That person's not even a contracting officer. I've seen contract specialists hold themselves out as contracting officers, so that's also a problem. So it's really important, again, you have that post-award debrief. At that point, you're going to know who the contracting officer is and keep tabs on that person or the grant officer, because again, only that person can obligate the federal government. And so what happens, anything that you hear from someone else, you need then the contracting officer, the grant officer to provide that direction in writing, not orally, in writing. And if it deals with an actual change, if it's an interpretation of a regulation, that's one thing. Great to get it in writing, and email will suffice. But if you're talking about funding changes, scope of work changes, applicability of certain terms, those need to be done through modifications to the agreement as well. So not only is it the authority, but it's also the binding authority. Oral communications from your contracting officer are very difficult to prove in court, and through a contract appeals board or trying to convince an IG that so-and-so told you that, I guarantee you that person's not going to admit to it once an IG is looking at them. So be very careful of who you're making agreements with post-award and how those agreements are being effectuated.
Jay, we have a question from the webinar audience. Can you ever rely on the grant officer or contract officer's advice or interpretation, and does estoppel ever apply? And remember, we have a lot of non-lawyers in the audience, and they need to explain the concept.
The concept of estoppel is that if someone of authority makes a statement, can the government then impose some sanction against you for following that advice? I would say it's going to depend, as any lawyer would say. It really is going to depend on the circumstances. If a contracting officer tells you, oh no, it's fine, you can give me that $100, that ticket to the World Series, they can't waive the gifts and gratuity rules. They can't waive statutes. Only Congress can waive statutes, or maybe the president. So it depends on what they're asking you to do. If they're interpreting something and the interpretation is reasonable, then maybe you have some reliance you can put on that. But again, you need to be very careful about it, because what they're telling you, if it runs contrary to some other authority, statutory, regulatory, then chances are you probably shouldn't rely on it. So it's a difficult question, but a good one.
And of course, it goes without saying to always get something in writing if you're going to rely on that. You may even need to get the contract amended, but certainly get something in writing. And it also goes without saying to consult with your counsel. Because just because a program or grant officer is telling you it's okay to do something, like you said, doesn't necessarily mean that's something they're allowed to tell you it's okay to do. And I know we have a question in the back, but Stephen, do you want to comment on something you and I have talked about before about, and you obviously alluded to this in your primary comments, but if we're not talking about the grant officer or the contract officer, but we're talking about program staff at the agency or others who are telling you, oh, it's okay to do this, it's okay for you to pay for this or to fly this person here or to spend the money in this way, what do you do in those situations? And what do you tell your staff when those situations occur, and they occur quite frequently?
Unfortunately, they do. I think this is one area that I deal with very frequently. And two things I'll say. As Diz said, generally in your agreement, you're going to have the delegation of authority for the agreement officer. You're also going to have a definition of the level of substantial involvement, and they're going to tell you who the grants officer representative is, or in the case of a contract, it might be the agreement officer's representative. All federal agencies have gotten very good at training agreement officers on their roles and responsibilities and delegation of authority, and it's part of their working their way up in their seniority and the level of warrant that they receive, so how much they can actually contractually encumber and financially encumber the federal government. But likewise, federal agencies devote a significant amount of time to training grants officer representatives, and they're going to be on the program side. If it's not in your agreement, specifically go to your agreement officer and request a copy of their delegation of authority so you can clearly see what their role is going to be. It's always going to be a technical guidance sort of role. It's going to be providing acceptance and approval of your deliverables, like your progress reports and your financial vouchering. But they have no authority to change the scope of work or to tell you how to go about spending your funds. You've got to be very careful in that regard. What Jeff is alluding to is with some of our agreements, other program staff within the federal agency are instructing our staff, and our staff want to satisfy the client. We're all about quality and delivering quality service and satisfying our clients. When they come to me, my first question is who asked and what is the nature of their request. Because if it's within the general parameters of the scope of work, they may in fact have the authority to do it. They're not necessarily changing any kind of obligation or scope of work. So first, it's important to understand the nature of the request. But if they really are asking you to do something that you can't do, then we have to politely push back. And a lot of my meetings with the head of the grants division revolve very much around this and having them meet with the various bureaus. Because when somebody who's the chief of the bureau at a certain federal agency, programmatically they're very important. They control a lot of programmatic issues within their bureau, but they do not have any contractual authority. And there are ways to push back, but I generally try to work it through with the agreement officer.
That was great, very helpful. All right, let's move on to number 9.
So number 9, any one of these topics we could probably use the entire time to talk about, but Stephen and I just wanted to outline some other items that are of, that everyone should take cognizance of and be aware of. The first one is the FCPA, the Foreign Corrupt Practices Act. For those organizations that do a lot of work or any work overseas, should be very well aware of this. Essentially, it is the application of our gifts and gratuity rules to foreign officials that U.S. companies will not, and U.S. individuals, citizens will not provide anything of value to foreign officials. Again, we could talk for hours about the terms of this, the exact nuances, the exceptions, the enforcement of it, but one thing just for everyone to keep in mind. The second is the gifts and gratuities, as I alluded to before. That's a statutory mandate, not something that can be waivable by a contracting officer. There are certainly a number of exceptions under those rules as well. it's important that all organizations familiarize themselves with that. But as we generally counsel our clients, best practice is really to stay well above the fray and have your company protocol not necessarily in line with all the exceptions of the gifts and gratuity rules, but maybe even be more stringent. It's just better to avoid, as we put it, an appearance of impropriety than it is to even get close to those rules. Conflicts of interest is one in the last couple of years has taken a really driver's seat with the federal government as they rely more and more on organizations to do their work. They've run into more and more conflicts of interest. A lot of times this will show up in your agreements through certifications, representations, and certifications that you don't have either OCI's, organizational conflicts of interest, or PCI's, personal conflicts of interest. Again, be very careful. Those are representations and certifications. Those are considered statements to the government and can be prosecuted as such if they're inaccurate. Maintaining auditable records. This goes back to the timekeeping we talked about, but it goes to all records under a contract, especially cost-based type agreements where the government can audit every single dime associated with that agreement. It's important that you maintain all the records for the period of time required under the agreement. The agreements always specify how long you're to maintain those documents, and that's from the period of closeout, not from just the time of expiration. So oftentimes it can be many, many years beyond the completion of a contract or a grant. The failure to comply with the Fly America agreement. I rarely get the fly on the government's dime, so I'll let Stephen talk about that.
Well, this is one I think just frustrates a lot of staff because you can generally fly cheaper on foreign carriers, but the U.S. government is very strict about adhering to the Fly America Act. Recently it got a little bit better when the European Union signed on to the Open Skies Agreement. So now as long as you are flying between a point of departure in the United States to a member of the EU who has signed on to the Open Skies Agreement, you can fly a foreign carrier. And so we've seen great satisfaction with staff as a result of that because it's now you've got much more options to schedule flights, and we have seen cost reductions which have also made the sponsor happy. There are some very specific requirements that if you're unable to fly on an American carrier, you have to meet one of 5 exceptions to the Fly America Act. And the critical and really important thing is that you actually have to document your file. And this is, as Des was just talking about, one of your auditable records. When you're going through your A-133 audit, the auditors are going to want to look to make sure that you've dotted the I's and crossed the T's, and you do have a justification for an exception to the Fly America Act. With our agreements with the State Department, if we are operating under an exception to the Fly America Act, we're actually supposed to submit our justification and itinerary with a copy of our invoice so that it's available to the agreement officer for a final determination. And if they agree that it was an allowable exception, then fine, nothing else happens. But if they challenge it, they will come back. And so it's very important to adhere to the regulations of Fly America.
And then just the last point, again, goes back to the idea of reading your agreement. A lot of agreements may have terms that deal with subcontracting, whether you can subcontract or subgrant at all. I've seen on a number of occasions where organizations have gone ahead and subgranted or subcontracted, and there's a specific provision in there that says you will not without consent, and they have not received consent. So again, always read those agreements. Number 10 is, and I'll touch on quickly, is not to leave everyone on a completely sour note and scared of the federal government as you walk out the door, but is misunderstanding the case of fraud. There's sometimes a misconception out there that you defrauded the government and you're a bad guy. Well, by defrauding the government, it doesn't mean that you intentionally, or it doesn't always mean that you intentionally tried to take money from the government that you weren't entitled. As I mentioned earlier, there is a much of a lesser standard for civil False Claims Act. And it's important that every organization understand that fully, that it doesn't require intent. It doesn't require anything more than reckless disregard. I don't know what that means, and I've been doing this for 10 years. So what reckless disregard is when you don't have a system set up to account for how you record your time. You don't have policies in place for your employees' email systems to maintain the records that are important to the performance of the grant or the agreement. That's an important area now that we're seeing on auditable documents, is that a lot of work is done over email, and a lot of decisions are made over email, and a lot of work is done over email. And sometimes people aren't filing their emails. They're ending up in their inbox, and just like my organization, this law firm, every now and then we purge a lot of unfiled emails, and organizations need to be cognizant of the fact that their records include electronic records. And so being mindful of maintaining a system of records, because otherwise you could be seen as in reckless disregard of the requirements under your agreement. So with that, I'll leave you on one last note. Last year was a boom year for the federal government. Fiscal year 2012, they recovered over $5 billion in FCA settlements, $3.3 billion of which was related to key TAM suits, which are whistleblower suits. And so it's certainly important for every organization to recognize that whistleblower suits, and as I mentioned, there's new protections out for the whistleblowers, that every organization be mindful of their employees' concerns and have a mechanism for employees to report concerns, so you can deal with those in-house rather than them going off to the IG or the Department of Justice because they don't feel they've had a voice within their organization. So with that, I'll close and answer any other questions.
Do we have any final questions from those of you here in the room? Yeah, in the back.
When the subcontractors, perhaps a foreign government agency or maybe even state university, can't comply with that requirement. Apply America, for example, for a foreign government agency, maybe that's not what it is. How do you handle that?
Be sure to repeat the question.
Yeah. So the question was, how do you enforce flow downs for sub-grantees or subcontractors that perhaps can't comply because of their status as an educational institution or another government perhaps? And then you asked specifically with respect to the Fly America Act.
Well, I just use that as an example. You have a foreign government agency and the sub-awardee, you can't force them to Fly America. I don't know if that's an exception to Fly America.
Yeah, no, that's so how do you work with foreign subrecipients that you're working with to ensure their ability to comply with flow-down provisions, and if they can't specifically, how do you deal with that?
Yeah, you said they comply to the extent that they're allowed to.
Okay. Well, using your specific example of Fly America, they have to adhere to it. There is no real exception to it. If they want to be reimbursed and paid for with U.S. government funds, it is a requirement of the agreement, and you're not going to be able to accept anything different. One of the ways we deal with that is we often purchase the tickets for foreign people coming to the United States so that we control the process and have the documentation. I can see other instances where somebody might say, well, I'm not subject to A133. It's a foreign concept to us. I'd have to look at each one of those on a case-by-case basis, but usually I try to work with them to understand the nature of the requirements, because it's not often that they can't, it's that they don't understand the requirement. And I've found by better taking time to adequately explain it to them and help them understand why it's important and why I can't waive that requirement, I generally am able to get people on board with it.
And at the end of the day, if it's an organization that you absolutely need as a sub-grantee or subcontractor, it's worth exploring with the contracting officer or the grant officer how to address the situation. Because otherwise the answer is if you can't comply, then you're not going to be one of our sub-recipients. But if that's not an option because of who they are or what they do, then really go back to the grant officer and explain the situation. But again, identifying that at the outset is a much better place to be in than non-compliance. So that would be my general advice. Mm-hmm.
And I would just second that, because I think especially when you're putting a bid together for the federal government, or you're assembling your team that you're going to work with, part of your due diligence up front is making sure that you have responsible subs working with you and that they do have adequate systems and procedures in place to administer U.S. federal funds in a manner consistent with the same standards that you're held to.
Especially overseas, the FCPA is one of those issues to always make sure you've done your diligence with.
Yeah.
Okay, a few minutes after 2 o'clock Eastern, I want to thank our speakers for a terrific job here today. We always love having my venerable colleagues speak to you about the legal side of things, but it's really nice when we can have non-lawyers, particularly from nonprofits, and especially our clients, come and be able to give a very different, unique perspective. I thought Stephen's comments were particularly insightful and helpful here today. I thought both our speakers did a great job. We hope to see you back here next month and in subsequent months. Keep a lookout for the email tomorrow that'll have a recording of today's program if you want to share it with your colleagues. And up on the screen there now are the links where you can find all of our recordings of our seminars and lots of other fun stuff. Thank you very much for coming.